Question 4 of the 2026 February bar exam. Let's jump right in. First thing you always want to do is go to the call to question. It really lays out what subject it is, and you'll get a good feel for what's going on. So number 1, does the federal court have subject matter jurisdiction? Okay, federal court, subject matter, tells me it's civil procedure. And also I know what subject matter jurisdiction, there's 2 ways to get into federal court. Federal question and diversity. Well, I've almost never seen it that I can recall an essay that dealt with federal question. It's almost always going to be diversity. So the party's completely diverse, and is the amount in controversy satisfied? Simple as that. Number 2, does the federal court have personal jurisdiction? Personal jurisdiction in simplest terms can be defined in one sentence. Did the defendant target, solicit, advertise, or do any intentional act within the form state? If so, they're going to be subject to personal jurisdiction there. Number 3, was Dan properly served? All right, well, Dan's an individual because he's not a corporation because they have his name there. So how do you serve an individual? FRCP Rule 4 has to do with you either hand it to him personally or you leave it at his house with someone of suitable age and discretion. Or you follow state law of where service is made or where the court is located. So those are the ways that you can actually serve under Rule 4. Don't forget, we follow the federal rules if we're in federal court. And because call the questions 1 and 2 mentioned federal court, I assume we're going to be applying federal law for this one. And number 4, how should the court rule on the plaintiff's motion to compel? Well, a motion to compel means that the other party is not willing to release certain information during discovery, usually because it's not discoverable, like privilege, or it's excessive. Those are the 2 main reasons. And so if the plaintiff doesn't agree, after they meet and confer, can file a motion to compel. So I have a very clear picture of what's going on in this essay. And in my honest opinion, this essay was a walk in the park. You'll be lucky that you got it. That's probably why I did it first. Dan, a citizen of Nevada. Well, I guarantee Dan's going to be the defendant because I know the way they write these exams, and they tell me he's a citizen of Nevada. I know we're not going to end up in Nevada because we're in California and we're taking the California bar exam. So right now I'd write on my paper, I'd put D, and I'd put underneath it N for Nevada. He was employed as a bus driver by Nevada Bus Lines. Now, I assume Nevada Bus Lines is incorporated, has its headquarters, or is at least a Nevada corporation. While working for the bus company, Dan was transporting master bingo players. I would love to know who is a master bingo player. That's like being good at slot machines from Thousand Oaks. I can already picture all these blue hairs on the bus. They're going from Nevada to Thousand Oaks, California to a bingo tournament when Dan dozed off. So Dan is acting carelessly, failed to stop at a red light, got negligence per se, and hit a car in Los Angeles, California. So the entire incident happened in Los Angeles, California. So there's going to be specific jurisdiction over Dan. And even it might be an implied consent law, and that has to do with when you drive on the roads in any state, you're implicitly consenting to jurisdiction there. So I wonder if the examiners were actually getting at that. The car struck by Dan was owned by Owen, O for Owen. And at the time of the accident, Owen's car was driven by Peggy. I guess P is going to be the plaintiff, the sole occupant. Got it. Peggy was rushed to the hospital and was treated for a broken wrist. Now, in federal court, you have to bring all your personal injury and property damages claim at the same time or you'll waive them. California is a little different, but we're not worried about California law on this one. The car was damaged beyond repair. Owen and Peggy are both lifelong residents of California. So we have Dan of Nevada, we have the Nevada Bus Lines in Nevada, and we have Dan and Peggy of California. So if those 2 separate parties are on different sides of the fence, we're going to have complete diversity. Peggy and Owen, and I love the way the examiners tell you that they're the plaintiffs, hired a lawyer, Larry, with a valid retainer agreement. Now, some people might think or pause for a second and go, wait, do I need to discuss any PR ethical rules? No, for 3 reasons. Number 1, it says a valid retainer agreement. That's the examiner's way of saying, do not discuss this issue. Number 2, nothing in the fact pattern, nothing in the calls of the question ask about any ethical violations. And finally, number 3, it doesn't say answer according to California and ABA authorities, which if you look at question 3 from this exam, it does. That tells you it's PR. So do not discuss the retainer agreement at all. You're not getting any points for doing so. They ignore it. In fact, it actually doesn't look great. So they file a civil action in federal court in Los Angeles. Okay, venue's proper, but they're not asking about venue. Federal court. So we have 2 California residents suing. Who are they suing? Plaintiffs' complaint named the Nevada Bus Company and Dan as defendants. Complete diversity exists. All we need is the amount of controversy. Slam dunk. Plaintiffs allege that Dan acted negligently, clearly Dan acted negligently, and that the bus company is liable as Dan's employer. That's what's called vicarious liability. We learned that in torts. Torts and civil procedure go hand in hand. Peggy demanded $100,000 in damages for medical expenses and pain and suffering. Price. Oh, then wonder she's not suing for the car because it's not her car. Okay. Peggy's amount in controversy is satisfied. So her claim against those defendants easily come in. And because both defendants are going to be jointly and severally liable, she can get $100,000 from each defendant. That's technically the way it's phrased, each defendant, when technically it should be either defendant. No matter what, she's only going to get one recovery of $100,000. Now, Owen demanded $50,000 for damage to his car. That claim does not meet the amount in controversy. And here's the interesting thing. Supplemental jurisdiction, which deals with related claims, is not used, cannot be used by the plaintiff in diversity cases. It's only used by the defendant. But there is one exception, and it's right here. It's the Exxon case, something that I hammered my students on. In fact, I gave them the essay, very similar to this. It's from 2013, if I recall. I could post that in the comments, let you know what the exact essay was, and I'll even probably give you that essay so you can see it. Very similar it is. So Owen's claim is not going to be aggregated. That is incorrect. If you said aggregation, that's incorrect. It's actually supplemental jurisdiction. It's a related claim by a completely diverse plaintiff, meaning that Owen does not actually kill Owen's presence in the lawsuit does not destroy diversity, and his monetarily insufficient claim, because Owen's claim is under $75,000, is the one situation where a plaintiff in a diversity case can use supplemental jurisdiction. So Owen can tack on his claim to Peggy because they're related and complete diversity still exists, even though Owen does not satisfy the amount of controversy. That's the one exception where supplemental jurisdiction can be used. Now, notice the first three paragraphs go to call one. And there's only one sentence in the whole thing that really goes to call two, and that has to do with the accident occurring there. Now, this fourth paragraph will go to call three, and the final paragraph will go to the final call of the question. Watch how this plays out. Larry went to Nevada and properly served the bus company with a complaint. Well, Larry's their attorney. So you're thinking, well, isn't Larry a party? No. Lawyers are not parties to the lawsuit, ironically. So they can actually serve. So this is, looks like it says properly served. And besides, the call of the question only asks about Dan being properly served. So we don't have to worry about the bus company. Which kind of gives you a hint. If Larry was able to properly serve them, then Larry could probably serve it on Dan too. The examiners give that one away. Larry then drove to Dan's residence in Nevada where no one was home. Well, it looks like it's his home, it's his residence, its usual place of abode. Larry slid a copy of the complaint under the front door of Dan's house. Not proper. You have to leave it with someone of suitable age and discretion who resides there. Nobody's there, and this is improper service. So was Dan properly served? The answer is no. However, little thing here. Dan received a complaint when he returned home, which is such a weird rule about the proper service, because the whole point of service of process is to give you notice to satisfy due process. Well, if you have notice, you're going to go to court to complain that you didn't get proper notice, which kind of defeats the whole purpose, in my opinion. Anyways, Dan received the complaint when he returned home, and both the bus company and Dan promptly answered the plaintiff's complaint. Does anyone spot the issue there? Dan has now lost the right to contest insufficient service of process under Rule 12b. And the thing is, in order for Dan to have challenged service of process, he would have needed to do so in the answer or pre-answer motion, whichever pleading or whichever comes first. Technically, a motion's not a pleading. So by Dan answering the complaint without raising the defense of insufficient service of process, Dan has now waived it. So even though Dan was not properly served in call number 3, he waived the ability to challenge it. And finally, in the last paragraph, in a request for production of documents, plaintiff sought all documents from the past 10 years. And if you haven't seen this before, it's been on 2 different civil procedure essays in the last 7 years. Past 10 years. They did a 20-year tax thing not too long ago, and I forgot what the other one was. But here, 10 years, to me, that might be excessive and not in proportion to the case. I mean, it's only a $150,000 case. Why do you need 10 years worth of claims? I think 2 to 3 years is sufficient, 5 tops, and that's even stretching it. So I'm already thinking to myself, this is probably excessive. And that's one of the new rules that came down, I think, in 2015. So they've been testing on that quite a bit. 10 years related to claims for injuries and property damages caused by their bus drivers. And even though this may not be admissible in evidence, because it technically kind of be character evidence, or it'd be kind of along the lines, I'm not really, but it doesn't matter because discovery is open to all discoverable and any evidence that could lead to discoverable evidence. So it's not, admissible evidence. So it's not limited to just admissible evidence. After meeting and conferring, which is what you have to do before you file a motion to compel or a protective order. The bus company refused to produce any documents in response to this request, and the plaintiffs filed a motion to compel, and of course, the bus company imposed the motion. So it looks like, how should the court rule on the plaintiff's motion to compel? I would probably deny it. I don't think I would order sanctions on the plaintiff, because technically that's what happens in these situations. But I don't think the court, I think what the court will do is probably limit discovery to 2 to 3 years, possibly 5. All right, and there you go. This essay, look, it was a walk in the park. Maybe you didn't catch the whole thing about Dan waiving the service, or you missed the fact that the Exxon case for supplemental jurisdiction applied, or maybe the motion to compel the 10 years was probably excessive. But leave in the comments. Let me know. This is Jason Tallarico from One Timers. It's my pleasure to go through it with you. Let me know if there's an essay or anything you want me to address. Go through. Let me know if I missed anything. I look forward to talking to you soon.